Hey, welcome back to the Law&Crime Network. I'm Bob Bianchi. I'll be your host from 12 to 3. If you can't get excited about Supreme Court nomination hearings, we're going to make it exciting for you. I want to introduce our guest, Mike Koribanics. He's a certified criminal trial attorney. We were baby prosecutors together, have handled many cases. I'm glad to have him here. Welcome, Mike.
Thanks for having me here today, Bob.
Absolutely. Listen, Lindsey Graham's asking some questions, so let's get back into that hearing, and we'll discuss it on the other end. Well, welcome back to Law&Crime Network. These are fascinating hearings, and we have with us, I've already introduced to you, Mike Koribanics, but also via Skype, Hank Brennan is a criminal defense attorney, both in state and federal courts, an adjunct professor in trial practice at Suffolk Law School. Welcome, Hank.
Thank you. Good afternoon.
Good afternoon. Okay, listen, we just got a short period of time, but we were in a really critical area there. The Roe question got asked, and the question about precedent. And Mike, he gave the basic answer that precedent is very valuable and that he would listen to both sides. Do you think he gave the right response, or is he about to get hammered by the Democrats?
I think this is such a passionate, politicized avenue. It's going to be difficult for him not to get hammered, but that really is the right question for a judge to read, or a potential candidate. Is, you know, you'd like to think every judge is going to follow precedent, but we know that they don't, because that's why we have new laws and we're always in a changing society.
Right. Hank, real quick, we got a minute left. Lindsey Graham had basically started talking about all the votes that the other justices got, even progressive justices, that advised consent is different now than it used to be. If you were qualified, you should get it. But don't they bear some burden for the fact that they wouldn't even give Merrick Garland a hearing? A little bit of hypocrisy there, don't you think?
It has depth of hypocrisy. Really, the history of how these hearings have progressed has changed dramatically over the last decade or so, and political gamesmanship is best.
Yeah, it's really unfortunate, Mike, with respect to that gamesmanship that's going on, because I do agree with the sentiment of Lindsey Graham. I was a person that went through advice and consent. You should be nominated, and if you're qualified, that should pretty much make it that way. But unfortunately, politically, people have done things differently, and that's a shame. Hey, Law&Crime Network, gavel to gavel coverage. We're going to take a short break and come back on the other end. Wow, there you go. Okay, they're taking a lunch break. This is something else. It's a grilling. These kind of confirmation hearings typically are. This one is very important because it's replacing Justice Kennedy, who was a swing vote on many issues that progressives were in favor of by one vote. So this could literally upend so many things from the areas of affirmative action and gay rights and Fourth Amendment issues, search and seizures, criminal law, environmental regulations. It's all over the place. We got Mike Koribanics with us, as well as Hank Brennan. Guys, I just want to say something here. We talked a little bit about some of the hypocrisy that goes on by both sides in these hearings, and it is unfortunate. When I was sitting there, you don't want to be twisted in the political process. You just want people to give you an up or down vote as to whether you're qualified for that position. And something that I also think is of interest is that when he was acting as a secretary in the White House, in the executive branch of government, that's very different than what you do as a judge. You may do things as a prosecutor. We're in the executive branch of government. I can do it because the law says I can. For example, I've tried death penalty cases, but if I were a judge, I would have found the death penalty in New Jersey, as it was constituted at the time, unconstitutional. There's not a contradiction in that. Mike, what do you think about that?
I think it's a great point you're making, because people are failing to realize you're talking about him as an attorney. We're advocates. We're not judges. Someone calls us. We're ethically obligated to put forth what our clients want us to do within our ethical means. But you're an advocate. As a judge, you're not an advocate. And that's where I think this is getting a little too political in trying to analyze what he did when he had clients to represent.
Right, exactly. And Hank, I'm curious about your position on these documents. It's been my opinion that if, in fact, this document dump, which just doesn't look good, and a lot of other documents that may be withheld that apparently even Senator Grassley is looking for, we're moving at a breakneck pace with this nomination where we stalled the Merrick Garland nomination to non-existence. I think if there's nothing as a smoking gun in those documents, it's an actual disservice to Judge Kavanaugh, because it's putting a mark of something's nefarious going on. What are your thoughts?
It does denote a sinister suggestion, but I think it may be a little bit of strategy as well. Remember, elections come up at the end of the season, and the Democrats can have hope that somehow the Senate shifts back to a Democrat-controlled Senate. So if there are documents, even if it's a fishing expedition and they may find something, although maybe unexpected, that could stall things, it is their hope, I believe, to try to extend these hearings past that time when they could actually make a difference, because now they're simply really powerless other than to voice their objection about stalling his nomination.
Yeah, if I were advising him, I'd be saying, give him the documents so it doesn't besmirch him. And by the way, if there's anything in there you don't like, you just argue there's a difference between being in the executive branch of government, judicial branch of government. You got 12 years of him being a judge, 300 opinions, 13 of which were affirmed by the Supreme Court. So that speaks loudly. Hey, Orrin Hatch asked some pretty interesting stuff. Let's take a look at that clip and talk about it on the other end.
For asking.
Welcome back. Okay, there you go. That's a biggie. The enhanced interrogation techniques, the torture memos, as it were. Mike Hank, I think that we're back to the same point again, where he's basically indicating that he's a conduit. He's a facilitator. He's not a person that was making policy, issuing policies, doing things at the directions of other people. There you see a picture of Judge Kavanaugh right now going through a brutal confirmation hearing because this confirmation is probably one of the most important nominations of the Supreme Court ever. How do you think he handled, Hank, the question of the enhanced interrogation?
Well, I think he handled it in a very savvy and political way. He takes a very objective position, distances himself without demeaning the people that he was tied to for years, and tries to make clear through the obviously softball question that he has no involvement in something that may be seen as a negative, cast a negative light on him. I think his answers are very smart. His answers are very political. He's not going to take a side or give us any real insight. He's going to have to defend certain attachments he's had with past decisions and associations, but I don't think we're going to hear any depth of attachment to a negative light. I think he's going to be very careful throughout these hearings.
Right. And I think that it's interesting, too, when we look at this nomination process, you come through a political system, Mike, and yet when you become a prosecutor, you become a judge, you're supposed to be independent, neutral, and free from politics. So it's really a strange thing, having gone through it myself. Do you think he's handling himself well, comporting himself well, especially given the fact that the ABA, just like when the judicial nominating committees would look at you from the Bar Association, gave him a unanimous endorsement as well qualified for the position. How's he handling that fact versus the political, where they're going after him because they don't like what he stands for and who nominated him?
Well, it's such an interesting question, and you make a good point. Is you become that individual person once you get there.
Yeah.
He's not there yet.
Yeah.
And I think he's doing a very good job of, really not answering the questions in detail because he doesn't have the details. They're asking him questions that are very general. And as a judge, you're not going to have general questions come before you that need to be solved. They're going to be very intricate. They're going to be very detailed, and they're going to be very well briefed. This is really all show.
Yeah, well, when you go through, that's an interesting thing. You go through this show, the bottom line is he got a lot of softball questions, but there are going to be a lot more questions coming from the Democrats on the other end of this. And when I was going through my contentious political process to become prosecutor, as you know well, somebody once said to me, you're not done until your hand's literally coming down from the Bible after you take the oath, even after you get approved by the committee. Orrin Hatch, he's got a couple more questions. Let's go back and listen to that, and then eventually we're going to get to some hardball questions that the Dems are sure to fire off. Okay, we got a short period of time. Hank, what are you making of this thing about this false testimony allegation? What is this about?
It's like a good direct examination. The people who are trying to support him are laying out his defense for him. And so they're trying to let him give a more full answer before the question's even asked. And it's a smart move by people who support him to try to allow him to be unequivocal, because when the questions start against him, as you see, oftentimes they're not questions at all. It's simply speeches until the advocate runs out of time. And so this is preparing him for his defense.
Right, yeah, and this allegation of lying is interesting because he has received very high marks by people of different political persuasion as a judge, Mike, where they said he's been fair, his temperament is fair, his judicial approach is fair. He gives people an opportunity to have their case fully litigated. He comes with very high marks that way. So this attack on his credibility is rough. 5 seconds or less. Is he doing a good job?
I think he's doing a good job, and I think you bring up a good point. You're judged by your peers, and his peers give him high grades.
Right, excellent. Listen, we're going to go to a break here at the Law and Crime Network. Love being on with you guys. We'll be right back. I'm here with Mike Koribanics and with Hank Brennan. Guys, you know one of the big things here is about what check and balance will there be on the President of the United States, especially given everything that's at stake with the Mueller investigation and these ideas of pardons, the abuse of pardons, and what about self-pardons? Let's go to Senator Patrick Leahy and listen to these interesting questions. Okay, there we go. Now, who says that this can't be sexy, Mike? I mean, and Hank. I mean, he got asked a direct question everyone in America wants to know, and he was ducking and jiving and moving and gyrating. I mean, look, it's a tough question, but I don't know, Hank. What do you think?
Well, it's the impossible question for him to answer because he doesn't want to tie himself to the sitting president. And by trying to posture it hypothetical and he can't answer it, he did just what you said. He ducked and weaved and he weaseled out of the question. But I suspect that there's going to be a lot of follow-up on that issue because that really is one of the hard arguments of the Democratic side.
Well, you know, I don't look at this as a Democrat issue and a Republican issue. When I give legal analysis, I try to do it straight down the middle. What's good for the goose is good for the gander. I don't know, Mike, your thoughts about the idea there just seems to be like power corrupts and absolute power corrupts absolutely, as they say. And the idea that you could self-pardon or not be held accountable, some would suggest the impeachment process is the level of accountability, just doesn't rub right to me. What are your thoughts?
Well, it sounds like some sort of like czar or dictator. I mean, this whole concept really, I can't believe anyone in this country who practices law or studies law would say that's a viable alternative where someone can self-pardon. It just doesn't seem, it seems to smack in the face of democracy and logic.
Yeah, and many of our viewers and our people in our chat room, which we love watching you guys and the questions, answering the questions, and one of the questions was, and it's important, it goes right to the heart of the matter. Some of these issues have never been decided before, and we have a constitution, and we need to look at basically the background, the history, the culture, our jurisprudence, precedent, as has been brought out here, and we need to ask ourselves that question. Is this presidential power so powerful that one can actually pardon themselves out of a crime, and if so, then does that not, Hank, set up a possibility of any president, not just this president, any president, being able to act completely unlawfully without any accountability?
Well, if a president could make his own rules, they could make themselves the president for the rest of their lives. So it is an abstract argument that has a lot of excitement when you talk about it. But I think when you look at the jurisprudence, clearly that type of power is quite limited with an executive. It's a nice conversation to have. It's an exciting talking point, but really the executive power is limited in many ways. A person can't pardon the office. They can pardon individuals. And so the president isn't in a position to draw his own protections in a criminal inquiry or an investigation in that way.
You know, okay, listen, my argument has always been to this, is that, in my mind, you swear to faithfully execute the laws, and that's the oath you take, and right there, that could be violated. But, guys, we are all over the place in the Law and Crime Network. Our producers are humming here. We got this hearing going on. We got the Liggins case that's going on. We're going to get to it all, but you know what I love best. Top crime stories lunch. Let's get to it.
Here are today's top crime stories trending on lawandcrime.com and across the country. A Chinese billionaire is facing charges in Minneapolis after being arrested on suspicion of criminal sexual misconduct. 45-year-old Liu Guangdong, who also goes by Richard Liu, was arrested and released from the Hennepin County Jail pending possible criminal charges. Liu, the founder of Chinese e-commerce website JD.com, faced previous accusations of sexual assault after a 2015 incident in Australia, which ultimately resulted in no charges being filed. Liu and JD.com claim he was falsely accused and will take the necessary legal action against false reporting or rumors. A man suspected of stealing from a farm in Maine Prairie Township, Minnesota, was apprehended after his getaway vehicle pooped out and got stuck in a pile of manure. 29-year-old Matthew Blumquist was arrested after he allegedly snatched lumber and other items before getting stuck in the waist-deep manure. Officers reportedly found Bloomquist standing on the side of the road covered in manure and smoking a cigarette. Bloomquist now faces charges of burglary and possession of stolen property, as well as a much-needed shower. Authorities in Texas have released the identity of a woman caught on camera crashing her car in a high-speed chase with police with her infant child in the back seat. Caitlin Rodriguez was arrested after she led police on a high-speed chase in San Antonio, crashed her vehicle, and tried to carjack another car while carrying her baby. The chase and crash was captured by police helicopter camera.
She's in the back seat. She's got the baby and we're running. We're running southbound from the accident.
Rodriguez now faces charges of child endangerment, possession of a controlled substance, and evading arrest. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Okay, Judge Kavanaugh hearing is in recess right now. We'll get back to that when that gets started. The Liggins case, Stanley Liggins, let's not forget, a 1990, that's 1990, 28-year ago, murder conviction that was overturned twice. He's on trial for the third time now in a brutal strangulation, rape, murder case where he is alleged to have set a young girl on fire and was put in a plastic bag, a trash bag. We have live testimony right now. You see him in court right now of, I guess they're at lunch, I'm being told. But let's go. Apparently, they had a witness that was on there that was analyzing the trash bags. So unfortunately, before we got to listen to that testimony, something else may have happened. So our producers are going to let me know where we're going to go from here in the Liggins case. But while I got Mike and Hank here, and they're going to let me know what's happening, Mike, this is like, I got to be honest to our viewers here. I'm disturbed by the idea a man as brutal a crime as this is, and maybe he did it, and he's done other things that he's been convicted of with sexual assault of minors, that 28 years later, because of prosecutorial misconduct on 2 occasions of substantialness in my mind, we are back for a third trial. I don't like it. What are your thoughts?
Bob, maybe because we were both trained in the same prosecutor's office years and years ago, probably when this trial started, it's just not right. I think it's a waste of resources. He's got 28 years in on this charge. And the scary thing is, what if he didn't do it?
Right.
That's really the scary part.
And Hank, to Mike's point, one of the things that was withheld is that one of their main witnesses was a paid informant, which, as you know, is something that is a substantial and fertile ground for cross-examination. In fact, the judge in most jurisdictions will read a jury charge at the end of the case and say you can completely disregard the testimony based on that. That was withheld. 77 police reports, which is just extraordinary to me. I've tried a lot of murder cases, Mike and Hank. I've never seen that, were withheld. And one involving the identification, which was very wobbly, where he says, well, it kind of looks like him. I'm not really sure. And the officer who took that identification, which would be a crucial witness for the defense today, is dead. How can this guy get a fair trial?
This case is littered with problems and fundamental unfairness. Whenever a witness is paid money by the government, not only is it right for cross-examination, but it has to call into question whether or not the person is telling the truth. Imagine a defense attorney calling a witness and paying them a fee to come and testify. The attorney would be disbarred. They would lose their license. And so to hide that evidence and not disclose it not only reflects on the case, but reflects on the prosecution team who's trying the case. It is outrageous that wasn't turned over. And this couldn't be just an aberration or some reckless conduct, because you mentioned the 77 reports. I've had cases where one report has been missing and I find it later and I lose my mind, because the idea of a fair trial is to try the facts, try the information that everybody has access to. So I think you're both right. When you look at this case, it's perplexing that they are trying it again after all this time with these issues that can never really be resolved. You can have legal opinions that allow the defense now to have access to information, but the witnesses' memories have faded. Other investigations they would have conducted are gone. So it really puts the defense in an extraordinary disadvantage at this point.
Yeah, and that's very well said. And guys, listen, I mean, I am a prosecutor at heart, assistant prosecutor for many years trying murder cases, the head prosecutor, and I would tell my staff all the time when I was the boss, as we were trained, Mike, when we were young assistant prosecutors, don't ever let us hear that you withheld exculpatory information information or Brady material, as they call that. I used to just open up my file to the defense before I tried a case. I'd take all my personal notes out, and I'd say, make sure you have all the data and information in there, because I don't want the conviction to have to come back. And, you know, with all due respect, prosecutors are supposed to seek justice, not just seek convictions. And to me, not only would have I dismissed this case as a judge, I think these prosecutors should be called on the carpet ethically for what they did here. Just my opinion. But listen, there's a friend of the family, Nathaniel Roden, that's on the stand, guys. Sorry to go off on my rant. I believe deeply in prosecutors doing the right thing, and if you don't, there's got to be consequences. But here we are. Maybe third time will be a charm for this defendant. Let's go to Nathaniel Roden and hear what he has to say. Okay, so this is the Liggins case. That's Nathaniel Roden, witness for the prosecution. I'm here with Mike Koribanics and Hank Brennan. I was having a little difficulty hearing, but at the very end, Hank, what do you think the prosecutor was trying to elicit from him? Why is he an important witness for them?
I think the difficulty with the prosecutor is they don't have an eyewitness to say somebody saw this accused commit the crime. So they're trying to put together and cobble together as many witnesses as they can to get the accused close to the crime, whether it was before the crime, after the crime. And so the proximity is what they're trying to establish. And it's something they need to do because they have that absence of an actual eyewitness or scientific evidence like DNA.
Yeah, and that's a good point, Hank, because the analysis has been that this is a very, very weak circumstantial case, Mike, which gets to the point of all those reports being withheld all that time. And as Hank is indicating, they're cobbling as many witnesses together, I guess, as they can to show that he's got some proximity. But you know, and let's talk to our audience about the mere presence at the scene of a crime or being in an area is not guilt.
Well, that's a very weak kind of evidence, but I think there's more of a danger to the prosecutor here because you heard this witness, you heard Ed Capian, who said he stopped by this house for a few beers. It seems like this was a party house. It doesn't seem like a house that was really a home where the children were protected, everybody was sort of on their own, which doesn't blame the victim, but what it says is it also opens to the defense that any one of these people could have had something to do with it because people were coming in and out of his house and partying. I think this was a Friday and a weekend. And it just is, it rings strange to me.
I think that's an excellent point. Hank, what do you think about the idea there's a defense lawyer that you'd be arguing, hey, it could have been one of these, any of these other people as well?
You know, and I think our connection's breaking up, so I apologize, but Mike makes a great point. In the point that it's creating third-party culprit. It's suggesting that this could have happened in a number of different ways. There's doubt. So it doesn't have a deep level of thought in trying to cobble these.
Okay, we think we got where you're going there, Hank, but, you know, one of the issues that I think is relevant here, Mike, it goes to this identification that the transcript is withheld that indicated that, well, it kind of looks like the guy, his photo had been out there. It really makes it suspicious. But listen, folks, we are doing it all. We're going to go back to the Kavanaugh hearing shortly. Law&Crime Network, we're going to be back on the other end of this break. Well, welcome back. That was Senator Dick Durbin, who has been a big opponent of this nomination, asking some questions. I have Hank Brennan with us and Mike Koribanics. Guys, let's talk about the first round, the questions about lying in the previous testimony. Now, Senator Durbin's a pretty accomplished trial attorney. He had his little chart out there, demonstrative evidence. I like it. But how many times can you get this, ask the same question and get a different answer? His answer seemed reasonable to me. I was interpreting the question as, was I involved in the actual policy making or implementation of this, as opposed to just kind of crossing my desk in my capacity as the secretary. Mike, what do you think about that?
I think no matter how long you do this, you always learn something new. But one of the things you learn is before you ask a question that you're going to use to get credibility, make sure the person who's answering it understands the terms the same way you do. Mm-hmm. I give that round to Judge Kavanaugh. I thought he looked bad. I thought Durbin looked like while he looked prepared with his picture, Kavanaugh took that picture apart.
Hank, we're talking about a little boxing match here. They're in the arena. Who won the first round on that lying piece, according to you?
Well, I have to agree with it. I think that when you look at a document or a statement as a lawyer, this is a very skilled lawyer, we want to read it a certain way. You have to be very open to seeing it from different perspectives. And so the judge's answers gave a very appropriate and understandable reason for why he answered that way. So I think the senator had quite the skill in approaching the question, but there wasn't much there to work with.
Well, the scorecard on that boxing one is 3-0 in favor of the judge, because I agree. Hey, listen, I understand, Hank, that you got to go. We really appreciate your time here. We're going to continue with the Law and Crime Network. We'll see you back next time.
It's been nice talking to you. Take care.
Absolutely. Mike, I want to go to the second round here, the abortion issue in the Garza case, talking about the minor and the precedential value. He got his precedent in there, talking about you try to get as close as you can. He had a couple of good one-liners, Judge Kavanaugh, when he was saying, hey, it's not my job to talk about policy, it's my job to interpret the law. What did you think as far as round two between Durbin and Judge Kavanaugh?
Politics aside, Judge Kavanaugh sounded like a legal scholar and a prepared judge, and I thought he did a good job of answering why he decided. And it didn't appear Durbin read that opinion very closely, because there was that question that really threw me was, well, it got to you, it got to him because somebody appealed it. He had to hear it.
Right. Yeah. You know what? It's like when you cross-examine an expert witness, you got to be careful that you know everything, because otherwise they're going to get you. And I think that happened. We're going to take a short break. We're going to come back on the other end. See you then. I beg the producers to let me and Mike just have 2 minutes to talk about what we just witnessed, because we're going to have a lot of platitudes and hi, how you doing, and how's your family, and thanks for being here. So we got a little time, Mike. Boy, Durbin versus Kavanaugh, round 3. I got to give it to the judge again. I'm really shocked that Senator Durbin, who's a very skilled or was trial attorney, that he basically got in a cage with that bear and he got tore up, Mike. The judge was impressive. What are your thoughts?
I think Durbin should take his chart and go home and call it a day.
Wow.
That was, listen, he is a skilled trial attorney, but that only goes to show you how skilled Kavanaugh is. I was thoroughly impressed at the way he justified and explained what he did, and the thoroughness in which he could recall. Bob, you and I have argued a lot of times. If we have one case in our favor, it's very difficult while you're arguing to remember all the things. Kavanaugh just rolls off. He was
actually correcting him. This is where you don't get in the cage with that bear. That would be right if you were a 2A, but what about 2B and the conflict and looking at the different precedent? And then in the end, I loved it when he whipsawed it around Kavanaugh and says, hey, I was disagreed with on another case, and everybody disagreed with me, all the other courts, and then eventually went to the Supreme Court, and I won. So that's just the way that goes. Don't you agree, Mike?
Well, I'm waiting to hear about a case he did that got reversed. We haven't heard about one of those yet.
Yeah. Well, listen, Durbin, I was really looking forward to that one, and unfortunately, not unfortunately, but whatever you want to call it, Judge Kavanaugh has done a great job in answering those questions. Listen, we're going to get back into that hearing right now, and hopefully come back with more commentary with my good friend Mike Koribanics, Law and Crime Network. Gavel to gavel on all. Right, I find this fascinating, Mike. So, I mean, there's so much. We got 2 minutes to try to put a lot of stuff out on the board here. I love the comment, because I believe it to be true. I just believe it to be true, that judicial independence is like being an umpire. I don't wear the jersey for one team or another team, Democrat or a Republican. I'm a judge judging the law. And that is a difference between what like I used to do versus when I became prosecutor, or what he used to do when he worked for the White House and then became a judge. And he kept referencing back to, look at my 300+ decisions and my record. What do you think?
Listen, I think you've got to find this a very impressive candidate. I can't say it enough because this becomes so politicized, but just his demeanor, his reflectiveness in his answers, and plus his, for lack of a better term, grace under pressure. I mean, this guy's answering important questions, and people are yelling in the background, being disruptive, and he's not shaken.
Yeah. He's unflappable, and boy, I don't know if he's citing the right things, but when he's talking about Section 2A, I believe he may have talked about the Federalist Papers, Article 78, but it sounds good, and he seems extremely knowledgeable. But I wanted to get into one other area. I found it interesting that Senator Cornyn was saying that judges don't run for office, no platform. They judge on a case-by-case basis. They don't have a team, back into that theme. And I believe that to be true. But isn't it interesting, in many jurisdictions and the lower courts, we elect our judges who are, in fact, on a team, and sometimes we've seen that affect their judicial independence. What are your thoughts?
Well, I think that's why you have guys like Judge Kavanaugh at the higher levels where they're more removed from the political situation, and they reflect, and they follow precedent, and they follow the Constitution, and they really listen to what's before them.
Right, and that system is set up specifically for the purpose of judicial independence, that once you get through the political process and you get it, you can be completely devoid of politics. I think it's the better of the two options as opposed to having elected judges, as I've often said. We're going to take a break. We'll be back on the other end with my friend Mike Koribanics. Well, Mike, we were sitting here talking about listening to Judge Kavanaugh and the depth and texture with which he's answering questions with an acute legal mind, to the point of citations to pages of decisions, to the history of the Constitution and the Founding Fathers, to the judicial temperament and philosophy. And you had made a comment, I don't disagree, you feel like it's the first time in a long time you've been back at law school.
It's just incredible. He's obviously very qualified. I'm very impressed. And the one thing I'm most impressed with is not only his ability to communicate by speaking, but the way he communicates when he listens. He really doesn't jump at anything until he fully understands the question. And that's really a gift.
Yeah, and he, we're back to this precedent again, the stare decisis, and for our viewers, this is this principle in law that he had indicated, that is the judge, that he believed it's for consistency and that there's value to precedent. But the senator just asks him a little bit of a curveball. What would be the kind of decision that you would think should overcome precedent or stare decisis, and where does he go? He goes to Plessy versus Ferguson and Brown versus the Board of Education, which he indicates, the judge, Plessy, separate but equal, was flawed from its outset, and that would be a reason under the 14th Amendment to Brown was the proper decision. So he's got a lot. He knows how to answer a question, and he's constitutionally accurate.
Well, he's got that little Constitution in his hand. I think he probably reads it daily.
Yeah, and that is a powerful, demonstrable thing. We talked about that as well. He comes out, it wasn't just like a new book either. It was all torn up and cornered or whatever. He's a very impressive guy. I mean, whether you're one side or the other, like you said, Mike, people are politicizing this. We tend to look at this as attorneys in terms of, are you qualified? Do you have the background? 307 judicial decisions, 13 upheld by the Supreme Court. We're going to have to go to a break with this fascinating hearing. We're going to come back on the other end with more analysis. Thanks, Mike.
Thank you.
Okay, we're back. I'm with Mike Koribanics from the Koribanics Law Firm out of Clifton, New Jersey. Mike, we really appreciate your analysis. We've known each other a really long time. It's good to be here, almost back from when we first met in law school, listening to like a law school thing here. And as trial lawyers who came up together as baby prosecutors, I want to give you, 10, 15 seconds. What's your overall feeling about what you're seeing? Because I know you were a little concerned about maybe coming on and talking about this, because it's not really you're a trial guy. You're not really like a Supreme Court, justice kind of person. And I think you're glad that you came on and we talked about it.
Well, I always, Bob, in this day, we're living everything so political that I was a little hesitant, because I really didn't know a lot about Kavanaugh until I did some research. And I just look at him from a lawyer's perspective, not a Republican or Democrat. But as a trial lawyer, like you said, regardless of his party, he's a guy you want to argue your case in front of, because at least he'll listen.
Right.
And if you know someone who's prepared, then as an advocate, it's your responsibility how to get them there.
You make a good point, Mike. We see this more and more in our legal analysis that we do, that people are politicizing it. We tend to look at it straight out as lawyers. Is this the judge I want to try a case in front of, or have a case? Will he be fair? Will he or she listen to the arguments? And do they have the intellectual capacity, the experience, the background? And again, people make it political. Oh, if you're in favor of him, then you must be in favor of the president or not. And it is regrettable, because these decisions are so important. And I think that we need more and more qualified judges. I'm talking about across the board. I think the judiciary has somewhat deprecated since we started. And certainly Judge Kavanaugh, he's got the goods, whether you like him or not.
That's right. He looks like, talking about boxing, it looks like he fought a lot of undercards, and he's ready for the big time.
Yeah, a little surprised, especially with Senator Durbin. I thought, from listening to his opening statements yesterday, he was going to score some points. But so far, we've scored on the scorecard. The judge has pretty much taken each one of them down on each argument intellectually, dispassionately. And I think some of the best answers I've heard coming out of a judge in terms of knowledge, background, history.
Another thing he said, Bob, it's like you and I have always addressed your juries this way, and maybe the public will think a little bit. Listen to these hearings. Stay focused on these hearings. Like we tell jurors, don't make a decision until you hear all the evidence. And I think this is what Kavanaugh's coming through. He's like saying, forget about everything. Listen to me and my answers, and then make your decision. So I think we all need to keep an open mind.
Excellent point. Hey, listen, Mike Koribanics, thank you for being here. We'll see you shortly on the Law and Crime Network, I'm sure, at Dan Abram's production. So let's go back to the hearing and see what's happening next.